Great. So why don't we get started? Welcome, everybody, to today's discussion, which is titled "A Former President Indicted, the Special Counsel, and the Road Ahead." This is a special summer edition of the NYU Law Forum, a discussion series on current events, legal and public policy issues, and intellectual ideas that we typically hold during the academic year. Our discussion today is special, and it's being held during the summer. It's co-sponsored by the Reiss Center on Law and Security and Just Security, both based here at NYU Law. I'm Ryan Goodman. A few pieces of housekeeping. First is, in terms of Q&A, we'll leave some time for questions from the audience at the end of the program. Audience members may submit questions in the webinar chat function at the bottom of the screen. I already see that's beginning to be populated. So I'll leave time at the end to draw from those questions and other questions that audience members have sent to us. For CLE, those seeking CLE credit, this event has been approved for one New York State CLE credit in the category of areas of professional practice. The credit is both transitional and non-transitional. It is appropriate for both experienced and newly admitted attorneys. I'll be announcing the CLE codes later in the program. Now, let me just introduce our outstanding panelists. I'll be pretty brief in the introductions because you've self-selected to come to the forum to hear from them, and they're also all very well known without any introduction. But first is Katie Benner, who's an award-winning journalist for the New York Times. She covers the Department of Justice and was part of the team that won a 2018 Pulitzer Prize for public service reporting on workplace sexual harassment issues. Sam Zakharoff is the Bonnie and Richard Reiss Professor of Constitutional Law here at NYU. He is a leading scholar in the study of democracy, constitutions, and the courts. He is the author, most recently, of the book Democracy Unmoored: Populism and the Corruption of Popular Sovereignty. Mary McCord is the executive director of the Institute for Constitutional Advocacy and Protection at Georgetown Law, where she is also a visiting professor. Mary was the acting assistant attorney general for the national security at the U.S. Department of Justice from 2016 to 2017, and before that had a distinguished career as a federal prosecutor. Along with our next speaker, she is a co-host of the MSNBC podcast Prosecuting Donald Trump. Andrew Weissman is a professor of practice at NYU Law and a distinguished senior fellow at the Reiss Center on Law and Security. He previously served as lead prosecutor in Robert Mueller's special counsel office, chief of the fraud section in the Department of Justice from 2015 to 2019, and as general counsel for the Federal Bureau of Investigation, the FBI. He co-hosts the Prosecuting Donald Trump podcast with Mary and is the author of the book Where Law Ends: Inside the Mueller Investigation. So to jump to the substance and then to start out with a question for Katie first, we're here today because of the first federal indictment of a former president of the United States in American history. Thursday of last week, the indictment was handed down, and then we all learned about the indictment when it was released publicly the next day on Friday. It includes 37 counts against former President Donald Trump. 31 of those counts are under the Espionage Act for the alleged willful retention of national defense information, or you could think of it as military secrets, and the failure to deliver those documents to officials who are authorized to receive them. So 31 counts under the Espionage Act, 6 obstruction-related charges, including causing false statements to be made to the U.S. government, and a conspiracy to obstruct with a junior aide who is a co-defendant in the case, Walt Nautow. The allegations in the indictment include what had already been widely reported in the press and from other government filings: the recovery of hundreds of classified documents from Mar-a-Lago. The indictment only charges for 31 of those classified documents, or documents marked as classified. And out of the 31 charges for the classified documents, or the documents marked as classified, 21 of them are marked as top secret, including top secret, which is compartmented information that's even higher than top secret. And some of them are so highly sensitive that, in fact, part of the classification marking has been redacted from the indictment. So I guess just to open this up, to ask Katie first, if you can kind of bring us to how we got here from the internal workings of the administration. Part of this might ask you in terms of speculation or what we know or what we might think. What is the process by which the Department of Justice got here? And if you had to speculate, what role do you think senior Department of Justice officials like the Attorney General, the Deputy Attorney General likely played in the decision-making of whether or not to bring an indictment? And then finally, I think another question that's been on many people's minds and has been part of the discussion, what role, if any, do we know of the White House playing any role in the decision whether or not to indict?
Sure. First of all, thanks, Ryan, for having me, and to NYU. This is a huge privilege to be on this panel, so thank you so much. And I think that you're right. This is a very interesting case because I'm going to just give you what I have based on reporting. I really hate speculation. I think that Mary and Andrew can help me out with some of the White House involvement questions. But in terms of what we know from reporting, this is an interesting case in part because when it fell into the Justice Department's lap, very few people inside of the department thought that it was going to end in an indictment. So I want to walk you through the timeline of this because it's really, really helpful in terms of how the Justice Department, to some degree, felt pulled along by Trump toward this endpoint. And we even had conversations with people about this in February, right after NARA, the National Archives Records, referred to the Justice Department this worry, and they sent a referral to the Justice Department saying, Donald Trump has classified information. We've received some boxes. We are concerned that we don't have all of the information. We want you to look into that. Even then, as we were reporting, we spoke with sources inside of the department who said, essentially, let's not get ahead of ourselves. Administrations have ended and classified information has left with the administration. Sometimes it's an accident. Please do not jump to any conclusion. There was not a sense within the Justice Department that this was going to end in an indictment. Truly, truly, this, which is what makes this so interesting, because a lot of people have brought up the point this is a problem of Donald Trump's own making. I don't think that can be emphasized enough. So that was, I made a little timeline, that was February 6th of 2022. And it's not until March 30 that the Justice Department believes, based on conversations with NARA, based on other sort of reporting that they're doing, it's not until 2 months later that they decide that they're going to need to probably use some sort of criminal process to coax the rest of the documents out of Donald Trump. That's, they didn't open this right away. So it's not until the end of March that they determined they need to do this. And then it's even a month later, with NARA continuing to ask the Trump team for documents, that the Justice Department decides that they need to act. And so they send a subpoena asking, we need these documents back. And then again, it's not even a month later until that, June 8th, when you see a representative from the National Security Division of the Justice Department, Jay Bratt, actually go to Mar-a-Lago to get what he has been told would be the remaining documents, with an attestation from a lawyer, Christina Bobb, that we now know was not true, basically saying that this is all there is. So that is such a strange process for the Justice Department, who was thinking for some of this time, we're just going to get the papers back and move on with our lives. And instead, they find themselves in this very weird situation where they feel that, as one person told me, things were just not on the level. We were not getting real answers, and we knew that this was going to be a problem. And so even in the spring, before Jay goes down to Mar-a-Lago, there are questions, what do we do if this team does not give us everything we need? Keep in mind, the criminal investigation has been open since March. They are gathering information. They are subpoenaing people. They are subpoenaing evidence. So they are understanding more and more that what they're being told does not make sense. And only 5 days later, Jay Bratt, after going to Mar-a-Lago, sends a letter to the Trump team saying, whatever else you have, preserve it, keep it in a safe room. We're coming for it. And you see conversations inside of the department really start to heat up. What in the world do we do? Knowing that there's a road that could lead to a search of Mar-a-Lago. How extreme would that be? How terrible would that be? What are the implications of that? And there is really robust debate, as has been reported in the Washington Post and other places. This is a debate happening between FBI leadership, the head of the criminal division and public integrity, National Security Division, and the Deputy Attorney General's office. And there is really robust conversation. This is not a decision made lightly. And it's not a decision that I would say people generally wanted to do. But when you believe that you are not being given the documents that you need that are national security documents, at some point you have to say, this is kind of a necessary step. And again, this is a problem of Trump's own making. And so when they are making this very serious decision, there is a sense of, if we're going to make this decision, we're going to need someday to explain to the American public why this extraordinary decision was necessary. And it's because we weren't getting what we needed. We weren't getting real answers. And I think that's another way of saying we were being obstructed in our investigation. And so what's so interesting when you read the indictment, especially on the obstruction charges and all the evidence in the indictment that supports that charge, it really hews very closely to the search warrant that the Justice Department obtained on August 5th and executed on August 8th. It really hews very, very closely, because even then they're saying in their minds, if we're going to do this, we need to be prepared to someday indict this as a crime, because we're making this very big public step saying, this person isn't giving us what we want. And so we're being pushed to this extreme. And again, I cannot emphasize more that if you would talk to somebody in February 2022, when they got the criminal referral from NARA, there was not a sense that this is going to end with this kind of indictment, with this kind of seriousness, including, with all the evidence that we see of the lengths that Donald Trump went to hide information from the government. Oh, and then in terms of whether or not the White House was involved, so again, this is where I'm sure Mary can really help out. When it was just the investigation, those conversations were tightly held within the Justice Department. They were not shared with the White House for a variety of reasons. One, just because Merrick Garland and Lisa Monaco truly believe that they are in their own lane in terms of prosecutions. You don't share those with the White House. Why would you? How do you uphold an independent standard of justice if you're running everything by the President of the United States when you're going to charge somebody with a crime, especially if it's the former president? So it was treated very seriously as something as an internal Justice Department matter. This was not shared. Garland was being briefed, but the debate was really happening in most cases below him. He was being briefed, he was being informed, and he would weigh in, but the real debate was happening just below him. And then when it came time to figure out how to evaluate the national security information and the involvement with the NSC, that's a little bit different. And of course, I think that's where Mary and Andrew can shed some light.
Yeah, Katie, that was such a great rundown. It was good for me to just reflect on the history here. And, listening to you, I could imagine myself in the position when I was both the acting assistant attorney general for national security and the principal deputy before that. And I can totally imagine the angst they felt at having to make decisions to take, criminal investigatory steps when they really would prefer not to for so many, many, many reasons. And so that really rang as something I could very much relate to. So, you're absolutely right. There are memos and guidance that require basically independence between the Department of Justice and the White House. It's called the no contacts policy, and that applies to most criminal cases. When you get into national security related cases, there are some differences because the Department of Justice is not the only U.S. government department that has a role in protecting our national security. I mean, we have more than a dozen national security agencies, and particularly where you have a situation where you are worried about potentially a spill of some of this classified information that could have been made available to people who are not entitled to receive it, including foreign adversaries who sometimes visited Mar-a-Lago. You don't know if there could have been transmission, but even aside from transmission, you don't know if people might have had access to it who shouldn't have had access to it. So you've got that national security threat that has to be discussed among the national security agencies. And there was a lot of discussion about this back at the time that the search became public and other things, that all of our national security agencies, led by the Director of National Intelligence, Avril Haines, were undertaking, a whole review from an intelligence perspective about what the harms may have been caused. And that would include things like figuring out, are there assets at risk, human assets at risk? Are there intelligence collection methods at risk? Are there hard conversations we need to have with our allies about how information that might be their information that we got from them might have been vulnerable? So those discussions at some point have to involve the National Security Council, which is really, an amalgamation of representatives from the different national security agencies who spend time detailed over to the White House as part of the National Security Council. The other discussions that would take place before you could get an indictment like this would be which top secret and other documents that are national defense information is the intelligence community going to allow the Department of Justice to not only put in an indictment, but ultimately prove to a jury actually contain national and defense information. And sometimes the sensitivity of the national defense information is so high that our intelligence community will say, no, you can't use that, because we would necessarily, to prove the case, Department of Justice, you would have to go into court and you would have to admit this is real national defense information, and it might involve, as it's been reported, nuclear weapons types of information. It could be vulnerabilities of our defenses or our allies' defenses. It could be our other capabilities, defensive wise. It could be offensive capabilities. It could be communications intelligence methods. All of these are things that our intelligence community holds very, very dear and close and doesn't reveal for a reason. So if some of that information, for example, and we know from the indictment, some of it is Department of Defense information, Department of State information, National Geospatial Intelligence information, National Security Agency, those agencies get to weigh in. Those conversations don't always take place at the White House, though. Those are often between the Department of Justice, including the FBI, and the agency directly, really negotiating, could we use this? Could we save this? Would you be comfortable if we did this? And is there a red line where at some point you'd say you can't go any further, and we can come back to that. And we realize we might be at the Department of Justice in the position of having to dismiss a count or even a case. And those conversations, and I'll let, Andrew may want to chime in here, those can be a little tense, because a lot of times the Department of Justice and the FBI feel really strongly that there should be accountability criminally. And sometimes our intelligence community says, we get it, we understand why there should be, but we can't do it.
Great. I want to turn to, and hopefully we can also turn back to the counterintelligence dimension of this. I want to turn back to the criminal case, and Andrew, ask you first just an assessment of how strong you think this indictment is compared to other indictments in this space using the Espionage Act and the like. And then what would you think is the strongest defense? And the strongest defense might be about the application of the criminal elements to the conduct, so does or does not have the requisite intent, or the strongest defense might be challenges to the ability to enter some of the evidence at trial. So that might be the strongest defense. What do you think is coming down the pike, at least?
Sure. Just one quick note, which is just to make sure people understand that what Mary was describing sort of at the front end, and then also prior to bringing an indictment, doesn't mean that outside agencies, including the White House, weigh in on whether an indictment should be brought. That decision people steer clear of. So you can have for instance, the intelligence agency saying you cannot use this document, or yes, we'll allow you to use this document, but they don't weigh in on something that everybody understands, at least in this administration and in, I would say, prior administrations, prior to the Trump administration, that's just not something that people weigh in on. I'm not saying that it would be illegal to weigh on it. It's a practice. So I just want to make sure that was clear. So I think that the indictment on the face of it is very strong. And I'll get to why I say on the face of it. I think it's always a little bit precarious when you just read the allegations to make a complete assessment. But the reason I think it is strong is, first, I think what Katie outlined, the timeline, is just very, very devastating on the two types of charges: the illegal retention which is charged for a time period of January 20th up through the date of the search, and the obstruction counts, which is charged from the period of the grand jury subpoena that was issued in May 11th, I believe, up through August. So during those time periods, essentially what Katie was outlining is one of the really strong pieces of proof for why that that information was there, why that the president, the former president, knew it was there, and the obstructive conduct because of the sort of drips and drabs problem. But in addition to that, so that's sort of one piece that you could imagine a prosecutor opening on and sort of giving that timeline. You have a reference to employees 1 and 2, low-level employees. We're not talking about people who appear, at least, to be sort of Michael Cohen type figures, people who have pled guilty with a lot of baggage. Michael Cohen famously has pleaded guilty to crimes including perjury. That makes a very difficult witness to put on the stand. These are sort of employees of Donald Trump's making. It makes it hard to attack by saying these are made up by the FBI or the FBI's created this evidence. Second, you have attorneys 1, 2, and 3 who are referenced. Again, that could be some of the most damning evidence, particularly on knowledge and on obstruction. That could be quite damning. You have reference to a tape recording and a transcript that is a partial transcript, at least in the indictment, of the former president with talking about classified documents that he says are in his possession, and with allegations of dissemination. Sorry about that. This is the welcome to doing this by video. You get to hear my dog. And as one aside, when I was teaching not on video, one of my students said, "Why would I take your class if I couldn't do this with your dog in the background?" Which was really just a great compliment to me. I'm just holding him here so that it won't be less noisy. So you have a tape recording. You also have references to text messages between the employees. One of the things that I look to, I prosecuted a lot of senior white-collar corporate executives. A standard defense in those cases is somebody saying, I either relied on accountants and lawyers, and also there were underlings doing this, and I didn't know what they were doing. And you know what? All of that could be true. The government has to be ready to deal with each and every one of those. None of those appear to be the problem here, because you have text messages that talk about a sort of maniacal interest that the former president had in reviewing the boxes himself. So on the face of it, that seems strong. The reason I say the face of it is we don't know how hostile those witnesses are. We don't know the baggage that the employees might have. We don't know if they have firsthand information, what kind of hearsay objections there might be to the employees and what they actually personally saw. I think there's a reason that the government was interested, by all reports from people like intrepid journalists like Katie, that they wanted Mr. Nauta to cooperate, because presumably he has that firsthand information, and that could pose either admissibility problems or just reliability if someone's hearing it through somebody else. And with the attorneys, one of the attorneys, Mr. Corcoran, who appears to be quite a central witness, is still counsel for Donald Trump. Who knows how long that's going to last? It's certainly unusual to be a star witness against your client and representing him in another case. But that does suggest that there may be problems in terms of how helpful he's going to want to be on the stand. Now, having said that, the Manhattan DA's office did a corporate prosecution of the Trump organizations, largely through hostile witnesses, and it can be a very effective way to try a case. So other things that the defense might do are things that are sort of outside of the courtroom. I think obviously jury selection is going to be quite important. They have a relatively favorable venue. I'm not a huge believer in looking at a venue based on who's a Democrat or a Republican and thinking that means you know what the outcome is. but they're certainly going to want to find people who are sympathetic to the former president. They have a judge who, in this very investigation, has been incredibly sympathetic and has been reversed twice for her ruling. So I think they have at least at this point, absent some sort of recusal, they have a judge who could be very helpful on the timing of the case, which could result in a pocket veto if the case can get put off until after the election, at which point one of the quote defenses here is really political, which is and frankly, I think that maybe the best defense is to go for a pardon. I mean, or if former President Trump becomes President Trump, he can just end the investigation by telling his Department of Justice to end it. I do think there are other motions we can expect, which are prosecutorial misconduct, which we've gotten reports about. I don't think that's particularly likely to lead to dismissal, but there could be hearings on it to either remove one of the attorneys on the case or just to embarrass the government. There can be motions to essentially reconsider the decision to pierce the attorney-client privilege based on crime fraud. I think, as Mary and I have talked about, I think that is an uphill battle, but because I think it's a right decision, and also it's a large part of that is law of the case, meaning that you don't really get to relitigate that. And Donald Trump, by all accounts, would have been heard. I mean, I've personally handled the exact same situation in the Manafort and Gates case before the exact same judge, and I know that the people whose interests are at stake get to be heard on the law points. They may not know all of the facts of the investigation, but that makes it very hard to re-litigate that issue. So I think those are all things that we can anticipate, but absent, I don't think there's anything sort of yet that I see in terms of a strong defense on the merits.
Great. So Sam, I wanted to turn to you with a kind of a broader perspective on some normative questions. So far we haven't really raised questions of, is this good for accountability, or is accountability always good? So the way in which I thought to frame the question to you is just your view on the unintended or consequences for US democratic norms and the rule of law with this momentous step that's now been taken of a first ever indictment of a former president by the Department of Justice. Do you worry that this action might open the gates to parties in power using the Department of Justice to go after their political opponents? Are there certain kinds of risks that you're thinking about, and how do you basically assess or evaluate them?
Well, thanks, Ryan. I think that this is a momentous event in American history, and it's one that generally does not bode well for democracy if you take a broader perspective of how this plays out internationally. The key to democracy is the ability to win today and lose tomorrow, or lose today and win tomorrow. It's called rotation in office. People have to be induced to leave office. It's not just getting in, it's getting them out. That's key to democratic stability. And democracies that prosecute former heads of state have a propensity to end up in the category of ex-democracies. So that's the big concern here for me. Now, at the same time, we've had a number of prosecutions of presidents or other heads of state in democratic countries. We just had the First Minister of Scotland have to leave office after she and her husband were indicted. We had former President Sarkozy indicted and prosecuted in France. We've had Vice President Kirchner and former President Bolsonaro in Brazil, President Zuma in South Africa. And so these countries have prosecuted their former heads of state and somehow have managed to maintain democratic integrity. And I think that there are 4 characteristics of when it's done right. This is always problematic, but there seem to be, just looking around the world, 4 characteristics. The first is that the offense for which the person is prosecuted has to be something that we call in law a malum in se. That is something that's a serious criminal wrong, no matter who commits it. So murder is an obvious malum in se, as opposed to a technical regulatory offense, which is something that basically people don't care about. And so we can contrast, for example, the indictment in New York City, as opposed to this one in federal court. The one in New York City at bottom was a rich man trying to cover up the fact that he tried to pay off a former mistress. It's ugly, it's unfortunate, but it's not the first time that has happened. And it's kind of a perennial expose. Without this sort of affair, page 6 of the Post would not exist, right? So that we have even a forum for this. By contrast, taking national security documents, including presumably nuclear, of those pertaining to nuclear capabilities, and showing them willfully to non-secured persons, that's got to strike everybody as just wrong, whether he did it or not. If someone were to do that, that would be a wrong. And so that is satisfied. The second is the political independence of the prosecuting authorities. This tends to be easier in civil law countries where you have a prosecutor who is an independent career civil servant or an investigative magistrate. It's harder where you have, most hard, where you have the prosecution being done directly by an elected official, as in the case in the New York City indictment. It's a little bit problematic because of the concept of the executive having some unitary features. And so at the head of it, you have the elected president, and the prosecution is done in the name of the executive branch, although we put up walls, as was described by Mary just a minute ago. The third is that there has to be a procedural order to the prosecution. It can't be, we went looking for our political enemies and this is what we found. And I think Katie's rendition of the facts here is so compelling on this point, because what we have at the end of the day is just an ordinary bureaucracy protecting itself. The folks in the archives, their job is, lo and behold, archives, right? They hold on to documents. That's their reason for living, is to amass documents. And they found some documents missing and they went to get them back. And that's as ordinary as it gets. And everything flowed from that. And what's more, we have the contrast with other people who have been in similar position and screwed up, whether it's Hillary Clinton or Mike Pence or whomever, or Joe Biden. And they came and they said, you have documents improperly. And so, sorry, here they are. We'll give you back and we'll help you find whatever you need. And at the end, there's nothing that happens. And that's why I think Katie's timeline is so critical. And the fourth one is that there has to be a sense of a prima facie case that's just overwhelming, that it has to be of such consequence, so serious. And here we have a bit of a problem, because that case has to be made not in court, but in the court of public opinion. And the difficulty is that we have nobody on the other side who can make that case effectively. Because if Jack Smith were to start holding press conferences, that would destroy the integrity of the investigation. And nobody above Jack Smith, neither Merrick Garland nor Joe Biden, can hold a press conference to do this. And so one has to hope that public discourse will gravitate to the inherent seriousness of these charges. This is not some guy paying off a mistress. And it's unfortunate, to my mind, that was the indictment in the first instance, because that's just not of a manifest level of seriousness the way that you have with national security documents. So I think that from what I can discern from successful foreign efforts, that the ones that work meet these 4 criteria to as great a degree as possible. And they are mostly met here with the complications of the way our federal government is structured.
I guess in a sense, the way the conversation has unfolded, it raises a question for me that kind of joins these different pieces. So I agree, Sam, with the thought that Katie's factual chronology is so important. And then Katie, but the question is that the information environment in which we exist in? So here we are in an NYU law forum where I think, a huge swath of the audience, if supermajority, is caring about the facts, the ideas, the merits. This is the conversation we're having. It's at that level, but it's such a rare conversation in a certain sense. And a huge swath of the public is going to think this is about a paperwork violation and everybody does it. And they won't have the facts as laid out by Katie, or be even able to hear them. So Katie, you think, I'm sure, a ton about, I know you think a ton about the information environment, how people get their news and information. And I guess, Sam, in some sense, it's not obviously just the question of whether or not it is that kind of crime, but that, as you're saying, it's about whether or not people understand it as such. And if half of the country, even 40%, 35% of the country gets a completely different story, I guess we're still in a bad place. And then that raises the other question I was going to ask in any case for counterintelligence questions. Mary, Andrew, do you think we'll ever get this information out there into the public in terms of senior U.S. intelligence officials being able to explain the ramifications independent of a trial, being able to present some of that to the public? Are there other ways in which some of this important understanding of the national security implications from this pattern of conduct can be presented to the American public for them to understand the nature of the allegations and the alleged, crime? So that's the question. So Katie, what do you think in some sense about what Sam just laid out? Is there hope within the information environments that we exist in that this can penetrate? And that's one of the questions from the audience. And Mary and Andrew, if you could also speak to where you think other parts of the U.S. government might or might not be able to touch this issue in terms of public education.
Yeah, this is such an interesting question because it's come up in so many different ways. So I'm just going to make a couple brief points because I really want to hear what Mary and Andrew have to say about this. I'm basically reporting on this panel as they speak, so this is important for me. But I will say a couple of things. One, there's been a lot made of getting live stream footage of this trial and of the pre-trial motions. And well, first of all, I just need to know people to know that, yes, of course, I support that transparency. And I think it's great. And I think it's wonderful. But the idea that it's going to do anything at all to combat misinformation and disinformation, I think is absurd. We all watched January 6th unfold on our televisions in real time, live, and we're completely horrified by it. And now all the same footage is being used to tell a completely different narrative by Republicans. And so I do not think that having access to the live stream is really going to be impactful in terms of combating misinformation. It's great for other reasons. We're still in a time like we've never seen before of complete information silos. And I think that we're seeing that impact on democracy. And this is a conversation for a totally different panel. What happens to freedom of speech with this kind of information infrastructure? Do we still have freedom of speech as conceived by the founding fathers and as understood by the United States of America basically until 2008? Do we have that now? I don't know that the answer is yes. And I think that that's a totally different issue to grapple with, but that has serious implications for this case. So that's one thought. Another, even just staying within this silo, there is this horrifying sort of paradox that I'm going to say reporters are eager to figure out what's in those 31 documents. And the minute we figure it out, we're going to publish it. And we already have an inkling that some of the documents relate to things that have already been published, conversations that Donald Trump was having about Iran and how to militarily respond to the regime. It's been in at least one book about Trump. It's been in countless news stories. So even as we try to talk about how serious this is, we are undercutting the government's argument that this has to remain top secret by talking about it all the time, publishing it, putting it on the front page of the New York Times, because then you can say, and this was a consideration in other, in previous cases, including the Hillary case, can we stand before a jury and say, national security will be extremely damaged and the lives of men and women in the military will be put into grave danger if this secret gets out? When we've talked about it on MSNBC, it was in Peter and Susan's book, we put it on the front page of the Times, we have op-eds about it, and we kind of got to almost 90% of the details We didn't get this 2 super secret ones, but so even our eagerness to make that argument, look how serious this was by exposing all of the information, we'll expose it and then nothing bad will happen. We will not see people killed and we will not see America at war with Iran. And so I think that is such an interesting, weird paradox that I hadn't really thought of before until I heard Sam speak. And I thought, okay, well, my job is to go out and expose all 31 documents, put them on the front page of the paper and make sure everybody knows what happened. And at the same time, then, Jack Smith and his prosecutors have to go for a court of law and say, wow, if any of this information ever got into the wild, it would really hurt American interests when the information will have been in the wild for months and months and months. So, I think that's just sort of an interest, and that's just within one news silo, within one tiny segment of the population that is giving more consideration to these things. We're not going to be able to control how this case is taken by a large swath of the population, especially since we're in a 2-party system and one party wants to put forth a narrative that what Donald Trump did was just fine. And that's going to be really hard to combat inside or outside of the courtroom.
If I could just respond. Oh, go ahead.
Go ahead, Sam.
This comes up every time a political official is prosecuted by the regime of the other party. So it's not unique to the United States. And there's no escaping it. The fact is, we speak that no one is above the law, but come on, guy's president of the United States. He got 75 million votes just about for president less than 3 years ago. He's the leading candidate for the presidency in 2024, according to recent polls at this point. So it's not going to be just a hands down narrative win on the part of the prosecution. And one of the paradoxes, and this is really what I think Mary and Andrew were sort of getting at and haven't addressed directly, one of the paradoxes is that we want to preserve prosecutorial independence as much as possible, and we want to silo it off from executive interference. But the decision to go after a former president is as freighted a political decision as one can imagine in a democracy. And so you have this paradox that you want prosecutorial independence in order to maintain the integrity of the legal process, but the prosecutors are not well positioned to evaluate the political consequences in just the same way that you laid out, that they're not particularly well positioned to evaluate the national security implications of these documents. But they have nobody to bring in that's the equivalent of the NSC to evaluate the political side of this for fear of compromising the integrity of their own investigation.
Mm-hmm.
The one part I agree with the part about the political consequences. I do think on the national security side, I'm not sure I agree with that. Mm-hmm. The department, one, is very, very steeped in national security.
You're right. Yeah.
And they also talk to and have enormously close ties to the CIA, the NSA, the FBI. That's obviously part of the department, so that they have the ability to assess, I think, that piece of it. But I think on the political side, I totally agree. And I was just going to make a quick point about sort of how does the department sort of deal with something where public acceptance of the charges, sort of, Sam, what you've been outlining as one of the criteria, and sort of how do you get the public to understand why this is consonant with the rule of law and why it's being done, and to Katie's point, sort of why this is so potentially serious or actually serious, whether it's retention or retention and dissemination, is that the department is steeped in a tradition of due process. And once charges are announced, as Merrick Garland keeps on saying, you speak through your public filings and that's it. And so there's maybe one opportunity to speak in a limited way upon the announcement of charges, and then you're supposed to put it in the vernacular, shut the hell up until the trial is over and there is a verdict. This is why for people like Mary and me, when what Jim Comey did was completely anathema. I mean, I remember being on a call at the time with a senior Department of Justice official. I was at the department at the time, and we were beside ourselves and incensed and almost tearful of nothing to do with politics. It had nothing to do with whether we liked or didn't like Hillary or Trump. It was the idea that this so violated core values of the department. And those core values, I think, can sort of go overboard in this sense. It's totally right to have that view, but it can lead to a pronouncement like Merrick Garland saying we're not going to speak at all. And I don't know that that's helpful. As an example, I don't think there's anything wrong if you don't talk about why the charged defendant is guilty, to talk about prior cases that are consistent with what you're doing, to try and deal with the issue of why is this something that's required by the rule of law and consistent with DOJ practice. That's something that the reason I think the department doesn't do that is because of this enormous reticence in terms of the role of the Department of Justice. So I think that exacerbates the problem of legitimacy when you've got a prosecution that's so controversial and people want that kind of data.
I like to go back to a few things that Katie said and try to answer your question, Ryan, too, about will there ever be an opportunity to sort of explain the harm from this? And I guess I have a couple of points there. One is that, regardless of whether after the investigation became public, intrepid reporters were able to get some sort of information that they then published, the question is going to be, was the information closely held by the government? And, is it the kind of information, the disclosure of which could cause harm to the government because it involves the national defense? And I don't think the timing of that, like the timing that matters there in terms of it being national defense information, is the timing when it's being retained by the former president and or taken from him or disseminated by him. And if thereafter it becomes reported through various means, including what's going to have to be produced at trial itself about the verification of this national defense information, is necessarily going to impact whether it's still closely held. But I think the operative time period is going to be the time period that the offense was committed, not what happens after that, at least in terms of the law. Now, two little caveats to that is, one, this isn't really a caveat to the law, but in terms of what the public thinks about it, then I'm with, some of the comments about if the public now thinks, well, now you've just put it in at trial, you've been public about it, it obviously can't harm the US anymore. So this is a big, a yawner. I don't need to worry about this. He shouldn't be convicted. That's always a challenge in cases like this. And sometimes the reason that the intelligence community would even agree that a certain document could be used in trial is because they've already done an assessment. They've already mitigated the damage. And they're at a point now where they can say, now, as of this date of this trial, we feel like we've mitigated the harm. That doesn't change what the harm would have been at the time that the offense was committed. That's sort of like thing one. And then the other piece to that is, the reporting on it in terms of whether the government closely held it does depend a little bit about how that reporting was revealed, right? And obviously, if there's government officials high level out there blabbing to reporters, then shame on them, they didn't closely hold it. But there are sometimes other ways that this stuff gets revealed. And I will tell you, and this is no shade on you, Katie, but because I respect, I have a journalism degree, I respect journalism very, very much, and you are a fantastic reporter, and I talk to you anytime you call, but I don't talk to you about classified.
Very, with all of those, but this is now going to be really bad.
Yeah. But I will tell you, the pressure that reporters put on government officials and former government officials to reveal classified information, I think is a serious problem. the day I left the department as the acting assistant attorney general, in the midst of the beginning of the Russia investigation, I had 2 reporters on my doorstep, my front
Weren't they my
door of
colleagues?
my home. Yes, I was not going to
Yes.
name them, Katie. I was not going to do that. And then I had others follow me on the metro. I had, they did want me to talk about classified. And I said, you guys know me. You know, I am not going to do that. Jeff Sessions will come after me in a heartbeat, and I will be in an orange jumpsuit, and I'm not doing it. But I just say this to say, there is a tension here, right? Between reporters thinking this is newsworthy and, you know, we want to push hard, and the pressure that puts on government officials. And because of policies within the department, generally speaking, reporters are not punished. It's the government official who is prosecuted. And so I just think that's something to always keep in mind. And the other thing I would say, and this is on the praise to reporters, is that even though, Katie, I think you acted like it's my job to go get as much of this and put it on the front page, as you know, that's not always the case. When there is a leak, when there is something that gets out there in the wild, when it is still sensitive and there are lives at risk, the department will often make a call to that reporter, and that includes your colleagues. And maybe you've had these phone calls, Katie.
I just had a call like that with my serious story. Like,
and say, please, please, please hold this story. Let us go get this human being out of harm's way, right? Let us talk to the Department of Defense and get the harm mitigated. Just hold the story. And reputable reporters like yourself, they hold the story.
So in some ways it's a segue, because I was about to also praise Katie for, you have obviously done, it's easy for me to say it, the best investigative work for the public to understand the status of the January 6 investigations inside the Justice Department and its potential trajectory. Do you think that what we've now seen with the first ever federal indictment coming out of the Justice Department, it tells us anything about the potential for the Justice Department to potentially bring indictments in the January 6 investigation on its own, or maybe there's independent ways in which you might have that kind of sense as to where the center of gravity is? Because in a way, there was always this idea, for example, that Attorney General Garland would be very concerned about bringing any kind of indictment out of fear that the department, even if it is following the rule of law, applying the law equally, would be painted as politicized. But this seems to suggest that he's overcome that concern, at least in this particular case of the classified documents. So that could be one way of thinking of that. It might actually open up the prospects of it, or it could go in the other direction, that there's been pressure on the department towards accountability type concerns, and they have now relieved the pressure by actually bringing an indictment in the classified documents. I've heard some people say, well, now there's the expectation, or maybe this is just purely speculative, Jack Smith will just issue a report in January 6th. Do you have a sense of how it might play out in one direction or the other?
so I'll just I'll just base this on the conversations I have had, especially with people who've had visibility kind of into both investigations. Keeping in mind that the documents investigation was a surprise. I mean, that wasn't something people anticipated even existing ever. They knew that January 6th would need to be contended with. I think that what the documents case shows us really is how Jack Smith works. It's a very methodical way. You know, when there were prosecutors in Florida working on this always, AUSAs in the Southern District. When Jack Smith took over both investigations, they were pretty independent from one another. All he did was bring them under one umbrella. There were a couple of overlapping witnesses, but the teams didn't really change that much, right? You know, he had AUSAs in Miami working with folks in the National Security Division. And on the January 6th side, it was the DC U.S. Attorney's Office, essentially working with, the Crim Division, and to some extent NSD, basically trying to work on two different issues. And that's sort of how it remained even under him. He was put over these investigations, again, to Sam's point, to show the independence of these investigations, to basically enhance their legitimacy in the public view. Garland has always said that he felt that the department, the men and women of the department, can do this on their own. They do not need that buffer. But the minute Trump was a candidate, he was like, there's absolutely no way to do it without this. And so, but what we saw in the documents case was that not only does Jack Smith work very methodically and and relatively rapidly when you think about how long he's actually had this case, he really wants to, he's careful on witnesses. He wanted 20 Secret Service people to be interviewed. He wants to know what everyone's going to say. So to Andrew's point, some of these witnesses are hostile. He knows that. So he wants to get a sense of what they could say, in Donald Trump's defense. He never wants to work with somebody and use them if he's blind to what they could say. He realizes there's risk there, certainly, and he doesn't think that all these witnesses are going to be perfect witnesses, but at least he won't be blindsided, and it gives his team a chance to come up with a powerful rebuttal. In creating the indictment, there were multiple rounds of conversation. Okay, if we're going to say this, how do we prove it? How do we support it? A lot. He really works in kind of almost, I don't want to say Socratic, but certainly he wants people to be challenging one another all the time to bring their best evidence. And if there's something that seems on the edge, just cut it. We do not need that. Why put that in the document if we won't be able to support it later, or if it seems iffy, etc. And so that's sort of the way he works. What's so interesting about January 6th is there's been a lot of reporting, especially in the last few months, that the team is now going back and re-interviewing people that they might have interviewed a year ago. And it says to me that he's going through a really similar process of, okay, if we're going to use this person, I really need to get them back in the witness stand. I need to know what they're going to say, good and bad. I need to understand where they're coming from, because if we're going to use them, no surprises. And what is our strongest case? And is this something we can let go? And that they're kind of going through that deliberative process right now. I would not say that this means there will or will not be an indictment against Donald Trump on January 6th. I think it just gives us a sense of his process. And if he truly believes that there is something that he believes can be proved beyond a reasonable doubt in a court of law, he'll bring it.
I would caution against seeing this indictment as a harbinger of what the decision is going to be regarding January 6th. The big issue in bringing this particular indictment was the fact of who Donald Trump is, the fact that he was the ex-president of the United States, the fact that he's the leading candidate for the presidency once more. January 6th introduces another element, which is what he is. That is, he was the sitting president at the time that he took the various actions on January 6th. To go and criminalize the conduct of a sitting president in his ongoing executive role is a step further. That's a really difficult step for the criminal law to engage. And I think he should be extremely cautious on that, beyond the political sensibilities that are involved with the fact that on the face of the indictment, somebody withheld and compromised important classified information that shouldn't have been in his possession and shouldn't have been compromised in that fashion. It's a wrong, no matter who does it, complicated by who it was. But using the criminal law to start going after the conduct of the president, that's a step further. I'm not saying it can't be done, but in my mind, that's really a step further.
Ryan, I don't know if you want to move on. I just wanted to briefly give
That'd be great. Yeah.
I mean, I agree with what Sam said, that it is a step further, but I think that what's going to animate Jack, and in part, it's worth remembering that he was a state prosecutor, he was a federal prosecutor in the field and at Maine Justice in various U.S. attorneys' offices, and I think is very aware of the really great outline that Sam gave about what to sort of look for in differentiating sort of legitimate prosecutions of a politician from illegitimate ones that we've seen around the world, because he was at the International Criminal Court. So I think he brings an unusual perspective for a career prosecutor to these issues, because he's actually seen it and dealt with it in the International Criminal Court. And I think, obviously, assuming that the evidence is there, that's obviously step one. I mean, obviously, if the case can't be made, game over. I'm assuming that piece. Assuming that, I think that, and I, by the way, totally agree with Katie's point, it's going to be super meticulous. I think he's going to want to know what the key witnesses say himself if it happened before his watch, I think that's one of the reasons I think he would want to have re-interviews, is like, just, I just think you can't be enough of a micromanager on something like this case, that's said by a micromanager. So I just think that, given the seriousness of the crime and the fact that there are so many people who have already been prosecuted for this, for engaging in conduct that is, I think he may view as much less serious as it is, but less serious, that he will feel that that if the proof is there, that justice requires it. And so I actually it's not just that it's this indictment that's the current indictment that's the harbinger. I do think that the process and what it tells us about him, combined with what I talked about, leads me to think that if the proof's there, he's going to go forward and by the way, for better or worse, and whatever it does in terms of the political arena, I think that is something we should anticipate.
I want to turn to audience questions. One question is, or a set of questions. There are a number of people have asked this similar question, which is, it sounds like the Trump legal team will make several efforts to exclude evidence from the trial, that might be one of the best strategies. And the question is, certain issues seem to have already been decided in DC by the federal district court and the Court of Appeals there. Are those final, or do they in fact bind the district court in Florida? So one example that different audience members mention is the idea of the district court in DC pierced the attorney-client privilege through the crime fraud exception and allowed certain evidence to be presented to the grand jury. Now the Trump team is suggesting that they will in fact try to have that reconsidered, at least for the purposes of admissibility of evidence at trial. Is that something they can do, or is the decision already being made? So maybe Andrew and Andrew.
Right, I'll start and then Andrew will chime in. So with the caveat that I have not done as fulsome research as I would want to do if I were the one briefing this, based on my experience and the research I've had time to do, I think that I think that the rulings made by the chief judge in the district court in DC, saying that the crime fraud exception applied and ordering Evan Corcoran, one of the lawyers for the former president, to testify and to produce his notes in response to a grand jury subpoena, that would be law of the case. And recall, it didn't just end with Beryl Howell's ruling. That was appealed to the DC Circuit. The DC Circuit rejected that appeal and affirmed the application of crime fraud. So that's actually been to a higher court level than the district court level. Generally, the way law of the case works is that legal decisions made at any stage of the proceeding, including the grand jury stage, are what govern throughout the proceeding. However, it's not entirely unassailable for a couple of reasons. One is there are some exceptions to that when the decision is so clearly erroneous that a manifest injustice would occur. So, for example, there's been a lot of discussion in other forums about the judge who's assigned to this case, Aileen Cannon, who already issued erroneous rulings that were reversed when she had the civil case that Trump brought to bar the Department of Justice from actually reviewing the classified information that they had seized pursuant to the search warrant. And she instead appointed a special master to handle issues of privilege like executive privilege, attorney-client privilege, etc. She was reversed not once, but twice on that, once when she refused to stay the case for appeal and once on the merits, and reversed pretty, soundly that you had no jurisdiction to even meddle in this criminal matter at all. So there are people who are concerned about her impartiality, and I think rightfully concerned about that. So you could potentially see her saying, I think that decision in DC was clearly erroneous and a manifest injustice would result, and I'm going to exclude this evidence. And I will say, though, decisions to exclude evidence are appealable by the government. So that is not something that the government would have to just live with and go to trial without that evidence. They would be able to appeal that, and I think they would appeal that. The other is a little bit trickier, and Andrew may want to weigh in here because this is something he and I have been going back and forth on. And this is something that Trump's former attorney, Parlator, was talking about on some media the other day, which is that to the extent that there are facts and things that the government seeks to elicit through Evan Corcoran or his notes that weren't really put in front of Judge Howell or the circuit and have to get evaluated to determine whether crime fraud applies to those facts, that might be wiggle room to exclude various things. And so, because remember, the decisions to pierce the attorney-client privilege were made before the attorney went in the grand jury, supplied his notes. So there hasn't been that opportunity to now go through and parse various bits of it and say, okay, this really is a crime fraud related statement, because this is something where the former president was trying to pressure his attorney to do something that would help him break the law, even if the attorney didn't have knowledge of that, or this is just an innocuous statement that really should be privileged. So there's still that kind of application. But Andrew, you may have another nuance to that.
So I totally agree with all of that, since I always agree with Mary as cool. But the one nuance is based on my experience before Beryl Howell, the then chief judge in DC, who we had the exact same issue arise in connection with an application in the Manafort and Gates case, where we pierced the attorney-client privilege. The one thing we don't know is how much the judge actually was involved in examining the details after the privilege was ruled to be pierced, because that was something she was, in the Manafort and Gates case, very involved in, to make sure that we only got what she ruled was within that scope. And she sort of very carefully scripted what we could ask and what the attorney could answer. So I that may not have happened here, but this is just a guess, knowing Beryl Howell, who's really meticulous, that she may have done that here. So to the extent she hasn't, then I totally agree with Mary. And there's reason to think there may be some wiggle room, but it may be something that she has actually already ruled on, and it may even have been part of what went to the circuit, but that's something we just don't know yet.
Can I just introduce a caution? I'm not a criminal prosecutor, but law of the case is one of the weaker of the exclusion or preclusion doctrines. And the application from one phase of proceeding to another in front of a different court is complicated, and I don't think there's strong law on that. What's more, when it's applied to say the district court is absolutely bound because of a ruling of the Court of Appeals, that tends to be in cases in which there's been an appeal from that district court, in that case, to the Court of Appeals. The Court of Appeals has reversed, it has come back down, and then the district court is categorically bound by that. That's the law of the case. This application is not conventional law of the case. I actually think that the ruling on crime fraud is perhaps the open legal issue of most significance from what I've seen.
I think, Katie, I think this one's directed at you, and probably about, I think it's about the January 6th investigation. So to the best of your knowledge, are there any high-level officials close to former President Trump left who have not cooperated when subpoenaed? Is anyone left who appears to be crucial or important to the case?
Yeah, I think that the primary official is Jeffrey Clark. So he was working at the Justice Department in the final weeks of the Trump administration. He was a top official. He was acting head of the civil division. The division's the largest part of the Justice Department. They're supposed to, defend the department, the administration's policies in a court of law and civil matters. So Clark, he wanted to erroneously say that the Justice Department had found fraud in a variety of states, including Georgia, and then ask top officials to send letters to Georgia first and then other states later, saying that those states should really basically scrap their election results, creating this huge delay in the certification of the election, if not overturning it. Now, Clark has not cooperated at all. And he has been really clear that he hasn't cooperated, but certainly because of his role both at the Justice Department and his many conversations with President Trump and Trump's allies, including other lawyers and lawmakers who are all part of this plan, he would be a key witness. And so one of the interesting things about the January 6th investigation is that it's not clear to me that it will get to Donald Trump. I don't know if that's the case, and for reasons both evidentiary reasons and the reasons that Sam had mentioned, I wouldn't want to weigh in or be predictive there. But I will say that there does seem to be a lot of question around the activity that people like Clark were involved in. And I think that some of the witnesses that have been brought back to, talk to the FBI or speak to the grand jury have been speaking to those moments. And so when you look at the people who are not cooperating, you do have to wonder what the Justice Department has in terms of evidence that could be used to charge people who are not Donald Trump, and whether or not there are cases to be made against people who aren't the former president, but who, in their actions worked to undermine the law, the Constitution, and a free and fair election.
Right. So we just got a little bit of time left. And I think what I want to do is just ask one last question. It's going to be to you, Mary, because one of the other hats that you wear in expertise is one of the country's foremost experts on militias and paramilitary groups and political violence. So is it that we can all breathe a sigh of relief that the former president of the United States is now being twice indicted, twice arraigned, and there was no upsurge of political violence or mass violent kind of demonstrations, even though he was calling for some demonstrations in his support? Or is that a false sense of security? And what are you thinking about in terms of the trajectory or concerns about political violence in the country?
Yeah, I don't think we can breathe a sigh of relief. There's no question that during the, after the Manhattan indictment, and then again after, of course, this indictment, there were not huge crowds. There were bigger crowds, I think, in Miami than there were in Manhattan, but they didn't become violent. They didn't attempt to storm the courthouse or break windows or assault police officers in order to get in and obstruct the proceedings. I think in part, they are concerned about the prosecutions after January 6th, and they don't want to find themselves, on the other side of the V, United States V. And I think they, when they come out to a protest like that, they're more inclined to, protest, but not be violent. What I worry more about is sort of lone actors that could be doing stuff anywhere, right? They're not going to be necessarily part of an organized paramilitary group. They're not going to be necessarily out there in their uniforms or with their matching flags at the courthouse, but they're very anti-FBI, they're very anti-DOJ, they're very anti-government. And we saw this after the execution of the search warrant, right? The attempted attack on the Cincinnati field office of the FBI. And so these are also that they're very much inspired by the group activity, disinformation, calls for violence by elected officials, not just like the former president, but current elected officials who are only thinly veiling their calls for violence. And those are the kind of people who will engage in sort of one-off acts of violence. And those are the hardest things to prepare for, just like our lone wolf actors who are inspired by foreign terrorist organizations. Those are the hardest things for law enforcement. And so vigilance, it's time for vigilance, not for resting on our laurels.
Great, thank you.
Got to end with a good downer from right? Can't be too positive here.
No. So with that, as a positive, I just want to say how grateful I am for you all lending your expertise to this conversation. You really are just an outstanding group of experts in your fields and in your work, and it's really been a rich conversation. I hope everybody has appreciated it, and that there'll be a video of this as well available to a wider audience. So really, thank you so much for contributing your thoughts and ideas. Really appreciate this at this most momentous time and this part of our history. So thank you.
Thank you, Ryan.
Thanks, Ryan.